Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
Let's go back to the Telegraph's main banner head across there. Don't defy the people, judges told, looking ahead to the Supreme Court tomorrow when the government begins its appeal against the High Court's decision, which said that it wasn't down to Theresa May to trigger Article 50, it had to go through Parliament.
Another brilliant example of newspaper journalists who, I'm sure, like me, went through the same training scheme where you were taught about the Constitution of the United Kingdom, and you know that what is actually happening here is that the Attorney General is opening a case at the Supreme Court, which means he makes a little speech and he says, this is what we would like, this is our argument, this is what we would like the court to consider. You don't tell judges what they can or can't do, you tell them what your argument is. So the headline is perhaps slightly stronger than it really quite ought to be. And actually what this is from some written submissions.
Have been told.
Yes, but they're not being ordered or instructed. But this is the top of this story says the Attorney General will today warn the Supreme Court they must do this, that, and the other. And actually what's happening is the Attorney General is leading this case. This is some written submissions ahead of what his argument will be tomorrow when the case opens. Those 11 judges will retire to consider it. They'll come back in January. There's not going to be an immediate return. Or they're going to come back fairly quick for the Supreme Court.
Come back in a week. It's absolutely ridiculous. 11
They've
most
got
senior.
To take Christmas off. They're going away to the
Exactly.
sun.
They can have the decision before Christmas. I think it's absurd. No, I don't think this case. I've spoken to Gina Miller on my talk radio show and in person, and I have to say I think it's appalling the abuse that she's had. I mean, God, on behalf of all leavers, I apologise to her, like not in my name or any other leaver I know that she's had abuse for bringing the case. But I don't think she should have brought the case, and I do think it's absurd to pretend that the judges are not bringing some of their personal views into this. We know that everybody brings their personal. The whole judiciary and the whole.
What journalists do? Judges aren't. That's the whole point of their training and their experience and their knowledge.
We are constantly told that we need to have judges who are more reflective of a diverse society. We need to have people who are from working class backgrounds, more women, more black people, more Asian people. We're constantly told. Now, why do we think that? Because people bring their own life experiences, their own views, and their own lives
or is it so that the public trusts the legal system?
No. The view is that people bring something to it. The reality is we have an entirely Europhile judiciary, an entirely Europhile, always legal world. They're all making huge amounts of money out of the EU. Of course they want us to stay in the EU. We may have the nonsense
but their jobs depend on following the law to the letter, don't they?
No, but if the law was that clear, we would never have court cases, would we? We'd never take a case to the High Court or Supreme Court. The point is that there is always an interpretation of the law. And our senior judges have repeatedly interpreted the European law and things like, the articles in human rights articles about right to privacy and things in absurd ways, not taking into account a lot of the small print about under these articles about you don't have a right to privacy or a family life if you've just committed a serious crime. I think it's a nonsense that a referendum that was a result of a parliamentary act voted by 6-1 from MPs in the House of Parliament, and that referendum decision was, we were told in a leaflet, would be enacted, would be implemented was the word, by the government, that this is now in dispute. No one in the Remain disputed this before June the 23rd, and the idea this is going to a court, if and when the government loses this case and it's taken to the European Court, there will be riots on the streets.
Do you think that's right?
I don't know. I'd quite like to see the government arguing the case for Brexit in the European Court. I think that'd be quite funny. The case in particular is not being brought because someone wants to overturn the referendum. It's being brought because it's being brought on the point of principle, which is that Parliament gets the final say over laws in this country, which is the reason why we elect MPs.
The people get the final say, and the Parliament are our representatives.
And who elects people to Parliament? The people.
We elected MPs, and they chose in a parliamentary vote.
I sat and listened to you quite politely.
Yeah, fair enough.
The case is being brought by someone who says that Parliament has the final say, and that is the way Parliament was established 1,000 years ago, to represent the people, and because people have been elected to go and serve there as our representatives. And although there has been a referendum, that Parliament should therefore scrutinise the referendum as it goes through. Now, the judges are being asked to rule upon that, but you've got three bits of the Constitution. You have the people, you have Parliament, you have judges, and you have the government. You have this executive that we expect them to kind of act in balance with each other. So judges and the executive and Parliament all have a little tug of war. That's how the Constitution works. And when things rock a little bit, one way or the other, it's not because one side is taking over from the other. Judges have a right to interpret these things. And unlike being in a criminal case where some diverse backgrounds, for example, would inform your decision about the person in front of you because they committed a crime or was accused of committing a crime, when you're considering the actual Constitution of the UK, which isn't written down anywhere, those judges are applying their expertise and a lifetime and a career of working out how the law works and what the words actually mean. And that's what they're going to be bending their minds to.
I think it's always going to be informed by your personal views.
OK, we have got to take a break there.
Before we start, I would like to raise a few matters. We order that no one shall publish or reveal the names or addresses of various parties, prospective claimants and interested parties in these proceedings, or any information likely to lead to the identification of those people or their families in connection with these proceedings, or the home address of the first respondent or any of the interested parties. Copies of this order with further details will be available to anybody who wishes to see it. We've made this order largely because various individuals have received threats of serious violence and unpleasant abuse in emails and other electronic communications. Threatening and abusing people because they are exercising their fundamental right to go to court undermines the rule of law. Anyone who communicates such threats or abuse should be aware that there are legal powers designed to ensure that access to the courts is available to everybody. Secondly, it's right to record that at the direction of the court, the registrar has asked all the parties involved in these proceedings whether they wish to ask any of the justices to stand down. All parties to the appeal have stated that they have no objection to any of us sitting on this appeal. Third, these proceedings involve a large number of parties and a great deal of legal submissions and supporting material, and the proceedings have come to this court very quickly. That this has occurred in an orderly fashion is entirely thanks to a lot of hard work done by and cooperation between the parties, their lawyers and the court staff. The justices would like to thank all those involved. There are an unprecedented number of lawyers and party representatives. We're grateful to them for agreeing seating arrangements, which involve many of them sitting in less convenient places than they may have expected. We've been keen to ensure that members of the public can be here, and given the limited space, this has meant that not all members of the legal teams can be accommodated in the courtroom. All parties have filed written submissions, which we've carefully read. Because of the limited time available for the hearing, we've had to ask some advocates to confine their submissions to their written argument, and others to spend less time developing their oral submissions than they would have wished. We're grateful for their cooperation and understanding. And I remind those advocates who will be addressing us that their oral submissions must not repeat points already raised by other advocates in earlier submissions. Next, many people are watching these proceedings because they are being streamed on our website and broadcast on television. This is a very important aspect of open justice, and we're pleased that so many people are able to read the written arguments online and listen to the oral arguments as they are being developed. Finally, I would like to take this opportunity to remind everyone who's taken an interest in these proceedings that the Supreme Court exists to decide points of law which fall within its jurisdiction. The justices of the court are of course aware of the public interest in this case, and we are aware of the strong feelings associated with the many other wider political questions surrounding the United Kingdom's departure from the European Union. However, as will be apparent from the arguments before us, those wider political questions are not the subject of this appeal. This appeal is concerned with legal issues, and as judges, our duty is to consider those issues impartially and to decide the case according to the law. That is what we will do.
Now, in the last hour, we've seen the opening of a landmark legal hearing at the Supreme Court. Over the next 4 days, the 11 justices sitting in London will decide whether Parliament's consent is required before ministers can trigger Article 50. That's the mechanism that means official Brexit negotiations can begin ahead of the UK's departure from the European Union. So a lot at stake. At the beginning of November, the High Court in England ruled that the government does not have power under the Crown's prerogative to give notice pursuant to Article 50 for the UK to withdraw from the European Union. In other words, the judges said it took an Act of Parliament to get us into the common market in 1972, and it will take an Act of Parliament to get us out. This led to criticism of the High Court judges by some parts of the press and some politicians, while the government said it would appeal to the Supreme Court. That appeal starts today and is expected to last most of the week. The original parties to the court case have been joined by lawyers for the Scottish and Welsh devolved administrations and a handful of other groups. The 10 male and 1 female judges are expected to deliver their verdict in the new year. If, as some commentators expect, the government loses, ministers will then bring forward a bill, possibly just 16 words long, which will then have to pass through both houses of Parliament. So the court began sitting just over an hour ago in Westminster, where unusually in the British legal system, the hearing is being televised. It began with the government's top legal officer and cabinet minister, Jeremy Wright, telling the court why they believed it was ministers and not Parliament who should start the UK's withdrawal from the EU.
There is nothing in the wording of the European Communities Act, or indeed in the later legislation to which Mr Eady will take you, to inhibit withdrawal from the European Union treaties or subject it to a requirement of prior legislative authority. That therefore remains to be done by the government in exercise of well-established prerogative powers. And it is not as though Parliament has been short of opportunities to impose such restrictions if it had wanted to. There has been legislation in 1978, in 2002, in 2008, in 2011 and in 2015, where it could have done so and did not. Secondly, nowhere in the 3 acts that followed the Lisbon Treaty in 2008, 2011 and 2015 is there any basis for inferring a legislative restriction on the prerogative in relation to Article 50 to begin negotiation of withdrawal. On the contrary, we say, close attention to the respective roles of government and legislature in this context has been given by Parliament in each of these acts, and the government's role on Article 50 has been consciously conserved.
Well, that was some of the government's legal case being presented there. Our correspondent Rob Watson is at the Supreme Court now. Rob, we certainly heard outside the court earlier a fairly highly charged atmosphere, and there is no doubt that the Supreme Court is under the spotlight in every way. How do you assess it?
Well, it's interesting, you got that clip there, and if it was highly charged outside, I mean, inside, O.J. Simpson, it is not, Joe. This is pretty dry legal stuff. But I'd sum it up in this way. I hesitate to do this with all those clever lawyers in there, but essentially we're at the point where the government is making its case, and it's making 3 points. Number one, that when Parliament authorised the referendum, they didn't say that somehow they're going to have to come back to Parliament. They knew all along that it would be the government that implemented the result of the referendum. The result of the referendum is clear, therefore the government should just get on and do it. The second point that's being made by the government is, look, if you go back a long time, but if you also take it right up to the modern times, prerogative, in other words, the government's ability to make foreign policy and treaties and unmake treaties, that is pretty clear, and that should apply now. And third, Parliament shouldn't worry, it's still sovereign, and of course it will have a role in the unfolding of the Brexit process, but just not in triggering Article 50. Is that clear, Joe?
Yes, that's it. We'll end it now. Tell them not to bother to sit for the rest of the week. I mean, on the other side, of course, was the critical issue that actually there are rights embedded in the legislation that took us in, and only Parliament can remove those rights. That is still holding for this case too, isn't it?
Well, that's certainly going to be what's put by the respondents as there. No, they will repeat that. But the government is essentially saying, or the government's lawyers essentially saying, look, hang on a minute, all that stuff is secondary because the referendum made it pretty clear Parliament knew what it was doing when it passed the bill authorising the referendum, and there was nothing in that bill saying, oh, and by the way, because rights are going to be handed over, you need to come back to Parliament. Now, of course, we'll hear later in the week from those saying, no, hang on a minute, there are rights involved here, and therefore Parliament is sovereign in this sense.
All right, Rob Watson
outside. Making it less clear now.
No, well, let's stop you then. Rob Watson, thank you very much outside the Supreme Court. Nadine Dorries, why shouldn't Parliament have a say?
Well, I think Parliament is going to have a say. I think Jeremy Corbyn's made it quite clear. Well, actually, no, I agree with the main point. The first point that the government is making in the court is that we have the right to do this. But it's almost academic. This court case is almost academic now, knowing that Labour are actually going to support Article 50 and vote for Article 50. And of course they're going to, because if they don't, we now have Paul Nuttall leading UKIP, who's going to take the charge into the Labour heartlands in the north of England. And any Labour MP in the northern constituency, with the turnout they had and the vote that they had to leave, who would dare to vote against Article 50, given the resurgence we're about to see of UKIP in those targeting those particular heartlands, would be a very brave and probably a very foolish MP as well.
Barry.
So given that Labour are going to support Article 50, this is almost academic, because it won't be the government. Parliament is going to vote Article 50 through anyway, and hopefully for the end of March.
Right, well, let Barry respond. Has Nadine Dorries sort of summed that up correctly, that that's how Labour is going to react and the reason why?
What I find fascinating is that Nadine seems to think that this court case is about politics. It's not. Fundamentally, this is a very important constitutional principle. And the principle is simply this. Does the Prime Minister have the right to overturn a law passed by the sovereign Parliament using the arbitrary power of the monarch? Now, the High Court found that the Prime Minister did not have that right. They said that the law created by Parliament can only be overturned by Parliament. That's a constitutional matter, and actually it needs clarified irrespective of Brexit.
Right.
Okay?
Do you agree? Because you didn't say... Hang on a second. You can do that, but there are 2 points just to answer. Do you agree? You say it's academic, but do you agree that Parliament should have a say? Do you think it's right that Parliament has a say?
No, I believe that... No.
Okay.
But can I just pick on something you just said? This court case is being brought by one millionaire, Gina Miller, and 11 other millionaires. For every one of the Gina Miller millionaires who have brought this court case, there are millions of Gerald Millers out there who went to the booth in good faith and put their tick in their box to leave the European Union. They don't have millions of pounds to bring a court case to argue a constitutional point. People were quite clear democratically about what they wanted. Right. They won a democratic vote to leave the European Union, and that is all that should matter.
And isn't this an attempt just to frustrate that?
Absolutely.
This is absolutely spurious, because actually the Labour Party, as Nadine well knows, and I, who was a Remainer, and the party were...
Are you taking that court case? Are you paying for it?
Could you just allow me to have the courtesy of being able to reply to your extended diatribe? I and the whole of the Labour Party are very clear, and our official position is very clear. The vote took place, Remain lost the vote, we will leave the European Union. The debate in Parliament and the vote in Parliament must be about what the shape of leaving looks like, and there must be clarity on that. What the government is continually doing, and what Nadine is trying to do, is to confuse the issue, because actually the government are confused and they have not decided what the shape of leave looks like. If they have, they need to come to Parliament, say, this is what we propose to do, and if that is consistent with all the things that were promised in the referendum, although we've heard lately that from both Boris and also from, I can't remember who the other one was.
Liam Fox?
From Liam Fox.
David Davis?
David Davis, that's the one. That three of the things that they've promised have actually... they're now saying, well, we may row back on that. We may row back on actually paying money to the European Union.
All right,
we may row back on free movement of people.
They haven't.
Well,
hang on, Nadine Dorries, there is a disagreement over whether or not having tariff-free access to the single market might be worth paying for.
No,
there is. David Davis has suggested that there could be a contribution made in the open negotiations. Boris at the weekend, Johnson, has said no, it wouldn't.
He didn't suggest.
Right.
He just didn't rule anything out.
Are you saying that the government has a clear
difference.
strategy, has a clear and agreed strategy?
Yes, the government, of course. course it does. And you know, and I would just like to make the point, I do not expect Theresa May to put her cards on the table so that 27 member states can keep theirs close to hers. David Davis did not suggest that. He just didn't rule it out. People voted for very clear.
But he didn't rule it out, but it's a red line for some people.
It's a red line. Why didn't he rule it out?
People vote.
If it's a red line, Nadine, and you believe it is, why didn't he rule it out?
Well, let her
Who
answer.
says it's a red line?
Some Tory MPs very clearly said, Stuart Jackson said it would be a red line to pay anything to the EU.
said it was a red line. He stood in front of the 5 principles and said these are the red lines that we have.
Let Nadine finish her point and then I'm coming to you.
It probably is, but what people very clearly voted for was exiting the European Union, control of our borders and access to the single market. That's what people voted for. It was very clear. When you say we don't know what Leave is going to look like, that is
it's very difficult not to talk over Nadine because she never stops.
I'm coming to you, though, in just a second. The question is, people voted to leave the EU. Did they vote on the manner in which Britain would leave the EU?
People put their trust in the government when they put their tick on. And the arguments were made very clearly during the referendum campaign. This is what it's going to look like. We will control our borders. We will control immigration. We will have access to the single market.
Right.
People knew absolutely what they were voting for, and that's what we're going to deliver.
Right. But to come back to Nadine Dorries' original point, Jeremy Corbyn has said you're not going to vote against the triggering of Article 50
indeed.
under any circumstances. Hang on, let me just ask the question. And does that mean you won't seek to amend the very short bill that will come? Right.
No, it doesn't.
So
Absolutely not.
So you could delay the triggering of it. Hang on, let Barry answer.
The point is here, the government, we'll have to see what bill the government comes forward with.
Right.
We'll have to see what shape that looks like. We will then, if it looks as if the government is heading for a hard Brexit, which is not in the interests of British companies, in British workforce. It's going to take away jobs. It's going to reduce our economic benefits in this country. If those are the things that the government is looking to do, we would look to amend that, and there would be a vote in Parliament. Now,
what does that mean, though, in practice? Because if you amended that, let's say because you wanted market access and protection...
It doesn't stop triggering Article 50.
Or the timetable.
It would say that Article 50 should be triggered on this basis rather than the basis that the government has brought forward. And that's why it's absolutely wrong of Nadine to continue to say that this is trying in some way to confound people who want to leave the European Union.
Right.
I believe that we now should leave the European Union because that is what the public voted for and that is also the official Labour Party position. But the government on that ballot paper did not give people the right to determine what the shape of it would be, what it would look like when we came out, to take away people's jobs, to reduce the economy.
Although the government was then trusted with the implementation of it, broadly speaking.
Well,
Can I just talk about the Lords?
Parliament was entrusted.
Let's talk about the Lords. Let's talk about the Lords, because if they are difficult, let's say, as you have stated, Labour in the Commons votes for Article 50 to be triggered and the end of March timetable, it looks as if it's being adhered to. What if there are problems in the Lords? What do you think should happen and Theresa May should do then?
Well, yeah, I don't like to sort of hypothecate on something that has yet to happen. I don't know if I were in the Lords, I would certainly be voting for it. I think the Lords will. You know, everything changes on a daily basis here. I think the Lords are more worried about reform. I think they're more worried about the fact that if they go against a democratic decision of the British people, that their position in the Lords will become even more tenuous in terms of their seats, and as the House of Lords is
right. Well, they're not elected, of course, in that sense, and reform
and
has failed by successive governments.
There may be reform that they may find unpalatable if they choose to go against the will of the British people.
Do you think the judges have strayed into political territory with this case, first in the High Court and now the same pressure in the Supreme Court?
Well, I go back to my substantive point. I don't believe this court case should be taking place because I don't believe that just a group of millionaires
what's the answer to my question, though, about judges?
The vote of millions of people.
And you've said that, but what about judges? Do they have a right to rule on what is a legal case that's been put before them, or are they enemies of the people, as some parts of the press
That's a very binary question, which is quite extreme. Look, we are where we are. These millionaires, these multimillionaires have challenged the British people, taken it to the courts. We will have to abide by what the judges say.
Can I just say,
finally,
it is ironic that Nadine is talking about these millionaires and multimillionaires, given that UKIP was bankrolled by millionaires and multimillionaires, and actually,
but they're not challenging the decision of the
Conservative Party. This court case in the Supreme Court is about a constitutional issue. It is politicians who have tried to politicise it, who put those articles into the press, personally criticising the judges and trying to delve into their private lives.
Is this the first time we'll hear you supporting bankers then, Barry? Because bankers are paying for it.
To make them feel uncomfortable about the decisions that they were taking. The judges have a job to do, which is a legal job about our constitution. They should be allowed to get on with it without politicians trying to politicise.
Right, well, we've got a few more days of this to go.
I've been